This program is brought to you by Emory University.
Good morning, everyone. My name is Kamala Wright. I'm the human trafficking prosecutor for Attorney General Sam Olens in the Attorney General's office. We wanted to start today with talking, because we are judges, because we are attorneys, of just making sure we lay the foundation of what we're talking about today and what the law is here in Georgia regarding human trafficking, so that we all know what we're talking about when we get on into all of the panels. So, human trafficking is broad. It covers adults and children. It covers labor and sexual servitude. What we see we see all types of trafficking here in Georgia, but what we see a lot of is domestic minor sex trafficking. You'll hear the terms thrown around CSEC, DMST. That is children who are under 18, and that covers sexual servitude. And this conference will cover all forms of human trafficking. The difference in our cases between adult victims and child victims is in adult sex cases and in all labor cases, you have to prove under the federal law, you'll hear force, fraud, and coercion. Under the state law, we have to prove coercion or deception. And our cutoff again for the age with human trafficking law is 18. So if you have a victim who is under 18, we do not have to prove coercion or deception. They can appear as willing. They can think they were completely willing. They are not allowed to consent to commercial sex, so they're sex trafficking victims, human trafficking victims. But with all of the labor cases and with our cases with adults over 18, we have to prove coercion or deception. We'll talk about where the definitions for that is in a minute. But one thing to remember is if what you're seeing in your courts is adult women, they're charged with prostitution charges, and perhaps they are not trafficking victims and no one is coercing and deceiving them, even if that is the case, remember that almost all adult victims were first in the prostitution life as child sex trafficking victims. So CSEC, like I said, it's commercial sexual exploitation of children. You'll also hear us throw around DMST, domestic minor sex trafficking. It's basically the sexual abuse of a child accompanied by remuneration in cash or in kind to the child or a third person or person. So it can look like child prostitution. It can look like a child being prostituted in exchange for money online, on the street. It could also look like a child having sex in exchange for a place to stay. It's any type of commercialization of sex. In Georgia, we use CSEC terminology because where children under 16 cannot consent to sex, children under 18 cannot consent to commercial sex. So regardless of how they act or appear, CSEC youth are kids who cannot be willing participants in commercial exchange for sex. And Georgia law recognizes these youth as victims of child abuse and victims of human trafficking. So what is CSEC, this sexual abuse of children? The normal age of entry is between ages of 12 and 14. That's what we see in our studies, and that's what we see in our identified child victims here in Georgia. That's what we see when we talk to our identified adult victims when they tell us the story, and the first time they were commercially sold for sex was around those ages of 12 to 14 or 15. Overwhelming number are runaways or throwaways. When we use those terms, runaway would be a child that's still being looked for. A throwaway is a child who doesn't even have a family looking for them, and we know we see them all in our courts. 70 to 90% have been sexually abused according to our studies, and we definitely see that in the victims that we work with here in Georgia, and that is prior to being trafficked. There was sexual abuse in the home. Most come from troubled homes, and there's, of course, truancy and school problems are very common. So whatever area of the courts you're covering, you can come across these victims. It's not just girls, it's boys too. Boys, we've seen, have actually higher rates of violence. They tend to become trafficked to meet their basic needs, place to stay, food, drugs if they have a drug dependency, whereas your girls are more often going to be trafficked for their emotional needs, the I love you, I'll take care of you, I'll support you. The average age of entry for boys is actually even younger, the studies have showed, and it is 11 to 13 years. So the law, like I promised. So Georgia human trafficking law is 16546. It was enacted in 2007, modified greatly in 2011, and again in 2016. So if you're dealing with these cases, you want to make sure you have the most current laws, because they are frequently changing almost every legislation session. Basically, it's anyone who knowingly recruits, entices, harbors, transports, provides, obtains, or maintains another person for the purpose of labor or sexual servitude. Sexual servitude is basically, if you have a minor, it is sex in exchange for something of value, whether that thing is promised, received, actually given. Sexually explicit conduct in exchange for something of value for any individual who's under 18 is sexual servitude. So back, anyone who knowingly recruits, entices, harbors, does any of these things. You transport somebody, you harbor them, you recruit them for sex in exchange for something of value, whether that's that Happy Meal or that $200, that is trafficking. Again, if you have an adult over 18, that's coercion or deception. Again, we'll talk about the definition of that, but we do have to prove that with adults. But we changed in the law just this year, bill brought by some of our senators and representatives, was we added developmental disability to this. This was a real push because it's what the GBI, and then talking to Attorney General Owens, they were really seeing is we're seeing these 25-year-olds who have the mentality of a 12-year-old being trafficked. So under D, we do not have to prove coercion or deception if someone with a developmental disability is being used basically for commercial sex. Provisions C and E of the definition basically cover undercover officers. It's sexually explicit conduct in exchange for something of value from an individual whom the accused believes is under the age of 18. We have our law enforcement out there going, we've got these very young looking agents, and they are, putting up ads, and they're saying, I'm 14, I'm 14, I'm 14. My mom's visiting my grandma in the hospital, but I have this hotel room. Those men that are showing up to buy that 14-year-old can now be charged as if they were buying a 14-year-old. Same thing with developmental disabilities. The penalties for this are 10 to 20 years generally. If you have a child, I said we don't have to prove coercion or deception. If you do have a child being coerced or deceived, the penalty goes up to 25, 50 years or life. And with the developmentally disabled, anytime you traffic someone with a developmental disability, the penalty is 25, 50 years or life, regardless of having coercion. So, again, sexually explicit conduct, just to make sure you know, it doesn't have to be sexual intercourse. It could be any of the sexual explicit conduct, which is basically covered in what you think of as your child porn laws. Labor servitude. So with any of these same things, anyone who recruits, entices, harbors, transports, provides, obtains, or maintains another person for the purpose of labor sexual servitude. Labor servitude is basically work induced by coercion or deception. So whether you are the driver in the enterprise or you are the recruiter in the enterprise, you are the ones housing them, work induced by coercion or labor is labor trafficking. It's all under our same law here in Georgia, 16546. So coercion or deception, which we need to prove for our adults, for our additional penalties, for our children, and for all of our labor. It's covered again in 16546. In the state, we have very broad definitions of coercion and deception. And obviously, you don't have to memorize this. That's why we have the statutes. But also, our Court of Appeals has recently delved into this issue. We got a very great ruling from the Court of Appeals affirmed by the Supreme Court now in Lemery v. State. That was our first case actually of male victims, and there was an adult male victim. And the adult male victim and his boyfriend were saying, either you bring me money from prostitution or I'm going to kick you out of your house and I'm going to stop giving you drugs. The court said, you take your victim, how they come. This kid had been kicked out of his house at a young age because he identified as homosexual, and the court said even though he was an adult, this was not his house. Threatening to make him leave the house was coercion. In addition to, we have specifically providing a controlled substance to an individual for the purpose of compelling the individual to engage in labor or sexual servitude against his or her will. So when you see these men and women charged with prostitution and they're doing it for a controlled substance, our laws in Georgia actually make them a trafficking victim, simply because they're being compelled, they're doing it against their will in order to get drugs to feed their drug habit. But also it can be threatening to, I'm going to show these pictures to someone, you're going to be embarrassed, you're going to be made fun of, or keeping the IDs, which we see in the international cases, but we also see in the domestic cases where he will have all of their IDs and she's going to stay there until she thinks he'll give it back. So some of the other briefly relevant laws for human trafficking, under the state law, and some of our Fed people know this, why I love our state law so much, we straight out said you don't have to prove the defendant knew her age. Lack of knowledge of age is not a defense in Georgia. Also, age of consent is not a defense. The fact that she could consent to sex when she was 16 does not mean that she could consent to commercial sex and being trafficked. Additionally, in addition to our basic rape shield laws, there's an extra one in 16546 that covers prior or post trafficking. So if you have a girl just because she has, and sadly very often have this, she has been trafficked before, we've got her pimp here that we've charged, and she ran away and found another pimp while he was in jail, doesn't matter, we're not proving coercion or deception, does not matter how willing she thinks she is. Remember, these are very, very broken children usually. That is not something that the defense can get into at trial. And there's also an affirmative defense against prostitution charges. So if you're dealing with an adult, if someone was being trafficked with coercion or deception, that's a defense against their prostitution charges. And of course with a minor, if they were being trafficked, not having to prove coercion or deception, that is affirmative defense against their prostitution charges. You have to recognize if you have someone under 18 who is charged with prostitution or has committed an act, been prostituted, they are a de facto human trafficking victim, whether they are a victim of their buyer or of their seller. The reason that word obtains was highlighted in the trafficking laws, that's very often what we charge our buyers with when we're charging our buyers with trafficking. Trafficking is now on the sex offender registry, and also we have a special provision about vehicles and money used in pimping or pandering of children or adults, trafficking, but also pimping and pandering of adults. There is forfeiture of the house and the money to the state. And just briefly, as a member of the Attorney General's office, I cannot advocate for any constitutional amendment, but one of the other recent laws that we have is on your ballots this year. Provision Amendment 2 will be for the Safe Harbor Amendment. If that passes, if enough people vote yes, they would establish a fund for victims of human trafficking. It would be for victims of human trafficking in addition to awareness and prevention programs. It would come from an additional $2,500 penalty for trafficking, pimping, pandering, prostitution type charges, as well as a 1% fee on the adult entertainment industry, gross revenue, or $5,000, whichever is greater. Of course, the purpose of that fund would be it wouldn't be money that would be in the general budget, would be in a protected fund that couldn't be touched by the General Assembly. And finally, case law. Our courts have brought us some tremendous case law in the last few years. Pepe Frazier v. State dealt with expert opinions in trafficking cases specifically, and in that case I used two experts. One is an expert in commercial sexual exploitation of children, CSEC, and another one is an expert in pimping culture terminology and the relationship dynamics between pimps and prostitutes. You will find in our cases, if you're actually in Superior Court trying our cases, that we tend to bring a lot of 404B motions because our pimps and traffickers almost never only traffic one person, but we find them in the past and we find them still trafficking girls from the jail. And Curry v. State dealt specifically with 404B in these cases, and in that case we used an adult willing person that he was pimping as a 404B for our child trafficking victim who he was working. I bring up the federal law here, even though I think we're mostly all state court judges, because our state law was completely just modeled after the federal law. The words are nearly identical, and they've dealt with two issues on the federal levels I think is important. One, that the statute is not overbroad. It does not violate the First Amendment, and that the trafficking law applies to buyers as well as sellers. Both of those, what they were dealing with was language completely identical to ours. So if it hasn't come up yet in the courts, then we end up looking to our federal courts. And now if I could have my fine boss, Attorney General Sam Olens, come.
Thank you, Kamala. So she's been a godsend to our office as far as taking the lead throughout the state. There's not a week that we're pretty much not in a different part of the state doing training. And I wanted to talk a little bit about that. But first, I want to thank everyone for coming for the program. I want to thank the sponsors. I, too, had the opportunity to go to the conference in New York, which was very, very enlightening. The whole ability of learning best practices around the country rather than just our state. And I wanted to give you some examples of why today is so important. You'll be hearing, for instance, and I'm always politically incorrect, so just get used to it, and for the folks I don't mention, so be it. One of the people that spoke, in addition to Judge Herbert that you'll hear from today, was Judge Camacho. And it's really my hope that the comments of Judge Camacho and Judge Herbert are going to talk to you about juvenile court and how to best deal with the young victims. There are too many judges in our state that look at these kids for sex crimes and view them as the defendant rather than viewing them as a victim. And I think from those two individuals, you're going to learn an awful lot about how the juvenile court judges, frankly, need to have a different periscope, shall we say, in that regard. Additionally, Kamala just talked to you a lot about the law that we have passed since 2011. When I took office, minimum was 1 year, max was 10. And now, as you know from Kamala, when we deal with a minor coercion or deception, it's 25 to 50 or life. And Kamala and Dahlia and a couple other state prosecutors have gotten life numerous times, which is so important. But we still see cases around the state, despite the numerous training sessions we've done, where folks don't get it. We see a case about an hour and a half from here where a magistrate judge refuses to keep the offense as trafficking because, quote unquote, it's a new crime. So then Kamala calls up the DA and says, let's go up to the grand jury and get the real crime. Or in the last week, I was given notice of a case in rural Georgia where a guy and his live-in girlfriend had a daughter. And starting at the age of 12, she was asked to provide services. And they would video the mom with the daughter and the guy's ex-girlfriend. So at times there were the three. And then there was one case of importance where an elected official was invited, literally, to have sex with the girl who at that time was 13. The prosecutor publicly offered probation, no jail. And the elected official declined because he did not want to be on the sex offender registry. How many bad things are in that fact pattern? So we're here in 2016, so we need to be educating not only the police and the detectives, not only the social workers and counselors in the school districts, and we know that when we do go to the school districts, the complaints that then go to DFACS and Georgia Cares are multiplied. We know that we need to be talking to the ADAs, and of course the importance today is the judges, because if you have something come in front of you, whether you're a juvenile court judge, magistrate judge, superior, state sitting for superior, and this looks like trafficking, you need to take a step back and think about it. If they are treating the buyer as simply a buyer when the child's 12 to 14 rather than 20, that's a problem. By that I mean the prosecution. if they are viewing this as a minor crime, that's a problem. See, one of the biggest things we have in front of us is to deal with the buyers. It's easy to go in front of a courtroom and get the judge to give many years for the seller. It's harder with the buyer. But the only way we're going to solve this crime is by dealing with the demand, and that requires a deterrence. When Johnny's dad is given 15 or 20 years in state prison for buying a kid, everyone who works with Johnny's dad and all of Johnny's neighbors and friends are going to pick up on it, and they're going to catch really quick that that's a huge problem for them. But as long as we sit there and say, run from the scene or it's a $100 fine, what are we teaching? So for instance, this weekend, one of these days this weekend, you assume Georgia will play South Carolina. And you'll assume that there will be a TV commercial advertising a retail establishment that will have more of a woman's chest out than in. And how many of those men are going to look at their teenage son and smile? Versus how many of those men are going to look at that teenage son and say that is a gift from God, not a sex object. So that's why we also talk to churches, because churches have men's club. And it's important for everyone, men in particular, to start having that discussion with our teenage sons. Because there is a continuum between teenage violence, domestic violence, sex trafficking, campus rape. In all of those cases, you're viewing the woman as someone who doesn't deserve respect. You're viewing the woman as someone who doesn't deserve better than that. And by woman, I don't care whether they're 9 or whether they're an elder. We've actually had a couple cases come in from GBI Director Vernon Keenan where we have seen elders trafficked. You want to stay in the place? You're providing sex to whoever I tell you. They're taking their Social Security checks. They're taking any checks they get. They may be living in the basement on the floor, but you're providing sex and we're videoing it, or you're out. And there was recently a good case that came out of Cobb County, case that came out of Augusta. We need to see more of that. You know, when we were passing House Bill 200 in 2011, it passed in the House pretty quickly with a lot of help from Edward Lindsay, and then Renee Unterman was charged to get it through the Senate, and Renee's been the saint who's been leading the charge in the legislature from the get-go. And there was a lot of opposition. You know, you're legalizing prostitution. These kids want to do it. Why are you trying to pass this law? There was a case that came out of Dodge County, and I use Dodge County specifically because many people view this as an urban problem rather than a national problem. So you had a mom and dad that had a 14-year-old girl and they had a minivan. And rather than make the $298 a month minivan payment, provide the daughter for sex and photos. We're under the old law. Used car lot manager, and dad got 10 years, mom got 8. That helped us get past the Senate, because that provided a different fact pattern than everyone was thinking about of someone abusing their own children. And when you see stings, whether it's through Backpage.com or the like, and you see where there's a setup in a motel, and you see a line of men waiting to do these kids one after another, up to 20, 25 or so times a night, it always amazes me that in some of these stings, you got a mom offering their daughter or stepdaughter. It's not just the public perception. Yes, there's a lot of organized gang activity, but it's anything and everything that we find in this space. So consequently, the more we train to include the judges, to know what's in front of you. So let me give you 2 examples. One, you got a prosecutor that's familiar with sex trafficking, and there may be telling the judge there's a plea for 20 years. And the judge says 20 years isn't enough. This is a heinous crime. I would hope that the judge would take a step back and understand the victim may not be cooperative. The victim, due to the Stockholm Syndrome and the like, may not be willing. A 20-year plea with an uncooperative victim may beat the alternative. So when you have an experienced prosecutor leading the charge, give the prosecutor the benefit of the doubt that they know what they're doing based on the testimony or the likelihood of testimony coming in the court. The other issue is the importance of training in that regard. So after we pass the bill, GBI starts training troopers. A trooper stops a car in Tolliver County. Guys driving, ladies in the front passenger seat. Lady won't talk to the trooper. Lady won't look at the trooper. He just recently went through the GBI training, and it just doesn't smell right to him. So he calls the GBI for backup. GBI comes for backup. They separate the driver from the kid. The kid was 17 from Birmingham. The kid had been trafficked since she was 12. Georgia was her fourth state. So the more we can educate anyone and everyone in the process, from the social worker and counselors at the schools, to the cops and the detectives, to the prosecutors, to the judges, the more you might have a different view of what's coming in your courtroom. Kamala provided all the law and a lot of the facts around these kids. But one of the big issues for us is, what do you do with these kids when you get them? So Kamala talked about Constitutional Amendment 2, safe harbor. So I get a call from a friend of mine, the DA at Chatham County, Meg Heap. And she goes, Sam, I got a victim, but I have no place for the victim to go. There's nothing on the coast. You know, Wellspring sponsors one of our hosts here. They have 31 beds, all women. No, none in the state specifically for boys. You've got places that cover homelessness, but there's a big difference between a young kid that's homeless and a young kid that's been sexually raped and psychologically raped day after day after day. So the idea of Constitutional Amendment 2 is that the first thing the state will create is a diagnostic center to figure out all that's needed for that child. And then once you cover all that's needed for the child, we need to have places around the state to provide that care. So that's the big benefit of Amendment 2. Now, one final thing, because I'll be catching y'all later towards the end of the day. Kamala did a great job of telling you where we are. Let's tell you where we're still not. We need the law to permit expungement. Those teenage or younger victims that were previously arrested for sex crimes should have their prior adjudications expunged. The fact that the judge at that time or the prosecutor at that time did not get the fact that they're a victim doesn't mean that those records should continue to exist. Even if they're not public to the world, they shouldn't exist. Those that relate to kids treated as adults, they should be expunged. If you're a victim, you're a victim. Number two, there's got to be mandatory jail time for the buyer. If you're buying a 12, 14-year-old kid, money alone doesn't do it. We need the jail time. We've got to have the jail time. Number three, we've got to have greater recognition in the state about how difficult it is to get these cases to a courtroom. There may not be any case more difficult for a prosecutor to bring to the court than a minor victim. Kamala, can you help me? I don't know where that video is. Than a minor victim as a witness in a sex trafficking trial. So that's huge, that y'all need to understand the difficulty there. What I want to show you is a quick PSA that we worked on to talk about the demand side. yes, it's gritty. So yes, it's gritty. It needs to be gritty, and we need to get the message out. Thank you very much.